In today's session, we are going to understand the interim verdict of Supreme Court on the Amendment Waqf Act. We'll also understand why the law was challenged, what the court has paused, and what continues to apply. And furthermore, how this case illustrates key constitutional doctrines like separation of power and reasonable limits as well. Hello everyone, welcome to Vajram and Ravi's Flash News. Today when we are going to talk about the interim order by Supreme Court on the Waqf Amendment Act of 2025, also known as Umeed Act, let us start with understanding that what exactly is Waqf, what the Amendment Act brought in, and then moving on to the interim order. So when we talk about the Waqf Amendment Act of 2025, it basically dealt with the management of properties related with the Waqf Board and Waqf itself. Now what is Waqf? Waqf is a permanent dedication of a property which can be done by a Muslim but for religious and charitable purposes. So when we talk about Waqf as a practice or the boards being associated with it, it is not seen in all countries. It is applicable in a few. It is practiced in a few, just like India. Can you tell me in the comment section which are the countries? Islamic countries mostly, but Waqf practice is not seen there. When we are talking about Waqf, we have to understand as a practice, once the property has been allocated for the religious or charitable purpose as Waqf, the irrevocability is not present there. That means it cannot be taken away. And as I said, there are many countries which lack the provision of Waqfs, but in India, we not only have Waqfs, but there exists a Waqf board. And in this scenario, we have found that Waqf board happens to be one of the largest urban landholders in India. So, in order to look into the provisions of this, Waqf board has existed. Waqf as a practice has been present in India since the times of Delhi Sultanate, and it was brought under the legal provisions through Waqf Act of 1995. Now, when the Waqf Amendment Act was brought in, that was originally introduced in 2024, but it came out in 2025. Now, a wide protest and many appeals to the Supreme Court went in because of the changes that it brought in. Changes such as inclusion of non-Muslim members, changes such as Waqf by user removed, then the power of the district collectorate in the scenario, and many such provisions. And that is why this matter landed up in Supreme Court, where Supreme Court delivered an interim order yesterday, especially on the 65 petitions which had challenged the Waqf Amendment Act of 2025. Now, this act had introduced wide changes, especially to the management of Waqf properties, and it also altered the management as well as the power that lay with the Waqf board itself. So, the court clearly, our Supreme Court clearly refused to stay the entire law based on the appeals, 65 appeals that have been made, but it went ahead and paused some contentious provisions till the final hearing. Now, this particular decision, where we are going to talk about the provision itself, becomes important for us to understand, not because of just the significance, but also the constitutional and legal impact that it would have, and what are the provisions that it is touching. That becomes important for us to understand. So, let us start with understanding the key provisions which have been highlighted in the interim order given by the Supreme Court. So, let us start with the ones which have been stayed as of now. First has been about the power of district collector, which was part of section 3C of the Waqf Amendment Act 2025. In this new law, the collector had the power to decide if the land which is claimed as Waqf, was it a government property or not. Now, the problem with this given power was that the property would immediately lose the Waqf status as soon as the inquiry started. There is no conclusion. The moment inquiry begins, the status is gone, and the officer could alter the records, and there is a possibility of foul play and also certain level of targeting and political misuse. In this particular scenario, SC has stayed this particular provision. They have stayed these clauses where property retains Waqf status till the inquiry is not completed and there is no direct correction of records, alteration of records that can take place through the officer. Then the second provision that has been stayed has been the non-Muslim members which have been included in the boards. So when we talk about the non-Muslim members which have the inclusion has been introduced through the Waqf Amendment Act, through the Waqf Amendment Act of 2025. In this scenario, the whole idea or the worrisome part was the risk of non-Muslim majority, especially in Central Waqf Council and the state boards that exist. To address this, the court went ahead and clearly capped it. The numbers were maximum 4 non-Muslims in Central Waqf Council, that is 22 members, and maximum 3 non-Muslims in state Waqf boards where it would have 11, where it has 11 members. So the assurity has been given from the Supreme Court that the non-Muslim majority, especially in the council and the boards, would not be there, and how it is going to maintain. The cap has also been introduced. Another provision that has been stayed, let's talk about the original provision. In the Amendment Act of 2025, Waqf Amendment Act of 2025, there was a provision that a person practicing Islam for 5 years, he will be only allowed to create a waqf. That means a property that can be dedicated to religious purposes. That can be only done by a person who has been practicing Islam for more than 5 years. Government had its own logic to explain this, but the problem here is there were no clear guidelines that how would there be verification in terms of practice of that particular person. So in this scenario also, SC has stayed this order till the government gives clarity and frames proper rules to verify the practice that they are talking about. Now let us move to the provisions that are the part which have not been stayed, that means the parts of the act which will still remain in force. The first one being abolition of Waqf by use. So when we talk about Waqf Act 1995, earlier there was this provision that if there was long use of Muslim religious or charitable purposes on a land, then it was automatically created as a waqf. Now the 2025 Act removed this concept so that there can be lesser misuse, encroachment, etc. And there was a lot of conflict in terms of government property and waqfs that had been created. So the court has allowed this change to operate to make sure that the misuse is gradually curbed and encroachment reduces. Furthermore, another provision that has been still kept in force is the application of Limitation Act. So the old law of 1995 exempted the waqfs from any limitation period in the property disputes. Now the new law applies the Limitation Act. That means there will be time bound suits especially for the encroachment. Court has not stayed this because it viewed as a level playing field that Waqf board or the Waqf members should not be getting any sort of privileges. It leaves them at a level playing field and it is not encroaching upon their rights in any sorts. Furthermore, this brings us to the point that what is the significance of this particular interim order and Supreme Court looking into this matter. The first and the most important point is Supreme Court looking into this matter brings in the balance of rights as well as regulation. SC, which stands as the protector of fundamental rights, it has protected communities' management rights, especially of Muslims, via Article 26, but at the same time SC has made sure that reforms which are being brought in, they are not unidirectional, they are not unilateral and arbitrary. Furthermore, there has been no disposition that has been seen. That means no third party rights have been given out. For example, if we are talking about waqf properties which are under dispute, they cannot be taken away or transferred until the inquiry has closed and the tribunal has given a decision on them. Furthermore, there is another significance. The stay that we are talking about on the provision there has been stay, this is also temporary. This will last till the constitutional validity of this whole act is decided by the Supreme Court. The government has also got a provision to frame rules, especially on the 5-year practice clause, so that it addresses the arbitrariness. Now, apart from the significance aspect from the whole idea of understanding the constitution and political situation better, now let us get into the constitutional or political takeaways from this particular interim order. So, the first thing that you can understand from here, you will find this is how on real level separation of power works. SC has held that interesting revenue officers, that is district collectors, with the power to finally decide ownership of Waqf properties. This was basically prima facie arbitrary. That means the separation of power that we get to see in the 3 organs of executive, judiciary as well as legislature. This is where one wing checks and balances the other, and this is how it works. So, this is a very classical example where we are seeing separation of power. Second thing that we got to see from here, another similar example for the separation of power. When we are talking about property disputes, there has been a clarification that has been made that the property title dispute should be settled by judicial bodies, for example, Waqf Tribunal, and not by executive official. That means they have not entitled executive official, they are not entitled to alter the records until there has been a final judgment on that. That also preserves the separation that exists between the executive as well as judiciary. This is another example that you can add and use. The second important factor that we get to see here is the reasonable restrictions that have been made on Article 26. So, if we talk about Article 26, it grants every religious denomination the right to manage its own affairs in the matters of religion. Second, own and acquire property. Third, administer such property according to law. Now, this is where we are getting to see that the judgment shows that rights, even fundamental rights, are not absolute, and the state will bring in reasonable regulations so that there is prevention of misuse, be it land, and ensuring transparency, as long as it doesn't destroy basic tenets of communities' core autonomy. This is very simple, a classic example that how our constitution helps us in balancing. This has also brought in interim relief jurisprudence. The court has very strategically calibrated an interim approach. It has stayed some provisions, it has allowed some provisions to stay in force, and this reflects that how courts can balance, especially at interim stage, the protection of fundamental rights also, presumption of constitutionality of laws as well, and the whole balance required to prevent the administrative chaos that can take place. Basically, all in all, we get to see that this order that has been passed, it is a classic case study where we find that judiciary is safeguarding minority rights as well as institutional fairness. At the same time, they are also respecting Parliament's intent to regulate religious endowments, especially transparency and land discipline that should be seen. What are your thoughts about this particular order that has come from Supreme Court? Let me know in the comment section. That was all from my side. Thank you so much.